Thank you for visiting the Combs Waterkotte website and our YouTube channel. Our criminal defense law firm in Illinois has over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, jury charge reductions, and victories. We have created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Aggravated Assault Lawyer in Chicago, Illinois. A conviction for aggravated assault in Chicago can lead to harsh penalties under Illinois law. In Cook County, aggravated assault can be charged as a felony, depending on the circumstances, leading to years in prison and the loss of certain civil rights. If you're facing an aggravated assault charge in Chicago, Illinois, or anywhere in the Cook County area, get in touch with Combs Waterkotte's experienced criminal defense lawyers as soon as you can. We'll fight for your rights and do everything in our power to minimize the effects of your aggravated assault charge on your life. Aggravated Assault Lawyers in Chicago, Illinois, serving all of Cook County. Combs Waterkotte understands that, in Chicago, aggravated assault incidents can occur in the heat of passion, or even from false allegations. As defense attorneys, we don't believe one honest mistake should ruin someone's life or get them sent to prison for years at a time, especially if someone is innocent and facing untrue accusations. When you use our firm to fight your aggravated assault charges, you get a personalized criminal defense strategy specific to the details of your case. We'll use our decades of combined legal experience and our deep knowledge of Illinois criminal law to combat the charges against you, scrutinizing every piece of evidence to weaken the prosecution's case. Our goal from the start is to negotiate with the prosecution to get your aggravated assault charges reduced or even dismissed. But if we have to, we'll be ready to fight at trial to achieve a not guilty verdict. If you're ready to fight back against your Chicago aggravated assault charges and secure your future and freedom, reach out to Combs Waterkotte online or give us a call today at 314-900-HELP. The sooner you get in touch, the better your chances of achieving a favorable conclusion in your case. What is aggravated assault in Chicago, Illinois? What is aggravated assault in Chicago, Illinois? To understand what aggravated assault is in Chicago, first, it's important to understand what an assault charge is. According to 720 ILCS 5/12-1, assault is defined as knowingly engaging in conduct which places another person in reasonable fear of receiving a battery. That begs the question, what is a battery? Under 720 ILCS 5/12-3, battery is when a person causes bodily harm to another or makes physical contact of an insulting or provoking nature. Essentially, assault in Chicago, Illinois is making a serious threat to harm someone else. What makes an assault aggravated, then? According to the state of Illinois, aggravated assault consists of much more severe threats made against certain individuals. There are 3 circumstances that must apply for an aggravated assault to occur under Illinois law. The offense must occur in a public place, like a street, park, or house of worship. The offense must occur against any of the following victim groups: a person with a physical disability, or a person over 60 years old, a teacher or school employee on or near school property, a park employee on or near park property, a security guard or utility worker performing their job, a police officer, corrections officer, firefighter, or EMS worker performing their job, an Illinois state government employee, a transit employee or passenger, a sport official officiating a game. The offense must include any of these acts: brandishing a deadly weapon, discharging a firearm, or flashing a firearm's laser sight at someone, wearing a hood or mask to conceal one's identity, driving at someone threateningly, as if to hit them with the vehicle. Any of those acts against any of those victim groups committed in a public place constitutes aggravated assault in Chicago or Cook County under Illinois law. Is aggravated assault a felony in Chicago, Illinois? Is aggravated assault a felony in Chicago, Illinois? Aggravated assault isn't always charged as a felony in Chicago, but it often is. The base-level charge for aggravated assault in Illinois is a Class A misdemeanor, an offense that results in up to 364 days in jail and a fine between $75 and $1,500. For aggravated assault to be charged as a felony, offenders must commit specific threats against specific groups. Aggravated assault is a Class 4 felony in Chicago, Illinois when the offender uses a Category 1, 2, or 3 weapon to threaten a security guard, utility worker, or state government employee. The offender brandishes a weapon at, shines a firearm laser at, or shoots towards a police officer, corrections officer, firefighter, or EMS worker performing their job. In Chicago and Cook County, a Class 4 aggravated assault felony conviction can result in 1 to 3 years in prison, or 3 to 6 years in prison for an extended term. Aggravated assault is a Class 3 felony in Chicago, Illinois, when the offender shoots from a vehicle at a police officer, corrections officer, firefighter, or EMS worker performing their job. The offender drives threateningly at, as if to hit, a police officer, corrections officer, firefighter, or EMS worker performing their job. In Chicago and Cook County, a Class 3 aggravated assault felony conviction can result in 2 to 5 years in prison, or 5 to 10 years for an extended term. How to beat an aggravated assault charge in Chicago, Illinois. How to beat an aggravated assault charge in Chicago, Illinois. If you've been charged or arrested for aggravated assault in Chicago, Illinois, your first and only priority should be retaining legal representation. A Chicago-based criminal defense attorney can be present to guide you through police interrogations, protect your rights under the law, and fight to get your charges reduced or dismissed. At Combs Waterkotte, we've helped hundreds of clients take on aggravated assault charges in the Chicago and Cook County area. We've found the following criminal defense strategies to be particularly effective in helping our clients beat felony aggravated assault charges. Self-defense. Self-defense is one of the most common strategies for fighting against aggravated assault charges in Chicago, Illinois. It involved demonstrating that the defendant reasonably believed force was necessary to prevent imminent harm to themselves. Illinois law allows the use of proportional force in self-defense circumstances. If the response was justified and not excessive, the conduct may be legally excused. Establishing immediacy, necessity, and reasonableness can shift the narrative from aggression to protection, often resulting in reduced charges or acquittal. Lack of intent. A lack of intent defense targets a key element of the aggravated assault law in Illinois: the mental state required to place another in reasonable fear of harm. In Chicago, criminal cases showing that the incident was accidental, misunderstood, or lacked any threatening purpose can defeat the charge. Evidence such as witness testimony or video may demonstrate that the defendant did not act knowingly or intentionally. Without proof of intent, prosecutors may not be able to meet their burden of proof, making this a strong strategy for securing an acquittal. Duress. A duress defense in Chicago aggravated assault charges focuses on proving that the defendant acted under the immediate threat of serious physical harm. leaving no reasonable opportunity to escape the situation. Unlike general pressure, duress requires a present and credible danger that would compel a reasonable person to act similarly. Demonstrating this level of duress can negate criminal intent. If successful, it shows that the defendant's conduct was a reaction to extreme circumstances rather than a voluntary assault. Defense of others. Using a defense of others, defense strategy in an aggravated assault case in Chicago involves showing the defendant reasonably believed someone else faced imminent harm and intervened with appropriate force. Illinois law permits individuals to protect third parties under circumstances similar to self-defense. If the response was proportionate and necessary to prevent injury or death, the conduct may be legally justified. Establishing the urgency of the situation and the reasonableness of the defendant's perception can undermine the prosecution's claim of unlawful threatening behavior. Coercion. A coercion defense in Chicago aggravated assault cases argues that the defendant acted only because they were threatened with immediate harm and had no reasonable way to refuse. If evidence shows another person forced the defendant's actions through intimidation or violence, liability may be reduced or even eliminated. Illinois law recognizes that criminal responsibility can be negated when free will is taken away from someone. Demonstrating credible threats combined with a lack of alternatives can mean that an alleged assault was not truly voluntary. Alibi. An alibi defense in Cook County and Chicago aggravated assault cases can be very powerful. This defense demonstrates that the accused was in a different location when the alleged incident occurred. If credible witnesses, surveillance footage, or digital records confirm the defendant's whereabouts, prosecutors may be unable to place them at the scene. Because aggravated assault requires proof that the defendant committed the threatening act, establishing a tight alibi can create reasonable doubt and lead to dismissal or acquittal. Miranda rights. Miranda rights violations can easily play a decisive role in an aggravated assault case in Chicago if law enforcement failed to properly advise a suspect of their right to remain silent and to have counsel present. Statements made during police interrogations without these warnings may be suppressed. If those statements are central to proving intent or threatening behavior, their exclusion can significantly weaken the prosecution's case. This defense focuses on ensuring constitutional safeguards were followed throughout the arrest and questioning process. Fifth Amendment. The Fifth Amendment provides important protections in Chicago aggravated assault cases by preventing self-incrimination and limiting the use of improperly obtained statements. If the defendant's confession or statements were coerced or taken without proper legal justification, they may be excluded. This can undermine the prosecution's case, especially when intent is already disputed. Asserting these rights ensures the burden remains on the state to prove guilt without relying on unconstitutional or unreliable admissions from the accused. Fourth Amendment. A Fourth Amendment defense can be critical in an aggravated assault case in Chicago when evidence was obtained through unlawful searches or seizures. If police violated constitutional protections like conducting a search without a warrant or probable cause, key evidence may be suppressed. Without that evidence, prosecutors may struggle to prove the elements of aggravated assault, including intent or conduct. Challenging the legality of police procedures can weaken the case significantly and, in some situations, result in reduced charges or outright dismissal. What to do if you're arrested for aggravated assault in Chicago? Being arrested for aggravating assault can be a tense and overwhelming situation. Even still, it's important to act in such a way that can preserve your innocence and aid in your criminal defense. The experienced assault lawyers at Combs Waterkotte request doing the following if you're arrested or charged for aggravated assault in Chicago. Exercise your right to remain silent. After an arrest, you have the right to remain silent under the Fifth Amendment. Do not answer questions about the alleged aggravated assault or provide explanations to police. Anything you say can be used against you in court. Politely inform officers that you are invoking your right to remain silent and request an attorney before any questioning begins. Request an attorney immediately. One of the most important steps after an aggravated assault arrest in Chicago is asking for an attorney with experience handling assault charges right away. Do not wait or attempt to handle questioning alone. An experienced lawyer can protect your rights, prevent damaging statements, and begin building your criminal defense strategy from the outset. Do not resist arrest or make any sudden movements. When you're placed under arrest for aggravated assault in Chicago, remain calm and avoid resisting law enforcement. Any physical resistance or aggressive behavior can lead to additional charges or escalate the situation. Comply with police instructions, even if you believe the arrest is unjust. Your attorney can challenge the legality of the arrest later. Your immediate priority should be avoiding further complications. Avoid discussing your case with anyone. Do not talk about your aggravated assault case with friends, family, or cellmates after your arrest. Conversations can be misinterpreted, repeated, or used as evidence against you. In Chicago prosecutions, even casual remarks can harm your defense. Only discuss the details of your case with your attorney, who is legally obligated to maintain confidentiality and protect your interests. Don't post about the incident on social media. After an aggravated assault arrest, avoid posting anything on social media. Prosecutors in the Cook County and Chicago area often review online activity for evidence that can be used against you. Even seemingly harmless posts or messages can be used out of context. Staying offline helps protect your defense and prevents unnecessary complications. Document everything you remember. As soon as you can, write down everything you remember about the incident and your arrest. Include details such as locations, witnesses, timelines, and police interactions. These notes can be valuable for your defense attorney when building your case. Even small details may be able to make a significant difference in challenging the prosecution's version of events.